My name is Heather Miller. I'm one of the adult programming librarians here at the La Crosse Public Library. Thank you for joining us on this gorgeous sunshiny day for the topic of estate planning. So without any further ado, I would love to welcome today's speaker. Please give a warm Monday morning welcome to local attorney Katelyn Doyle.
Thank you so much, Heather. My name is Katelyn Doyle. I'm an attorney at Johns Flaherty and Collins, and I specialize in estate planning. And so that's what I'm here to talk to you about today. Um, so a lot of people ask, like, do I really even need an estate plan? Often people think that estate plans and wills and trusts are only for individuals with a lot of money. But that's absolutely not true. Estate planning is important for everybody to have. It's for planning both during your lifetime for your incapacity and to plan for the distribution of your assets upon your death. Sure. Is that better? Okay. Sorry. Thank you. All right. So I'm going to start talking about planning for the distribution of your assets upon death, and then I'll talk about documents to get in place for your incapacity, potential incapacity towards the end of this presentation. Um, so first of all, what makes up your estate? Anybody want to throw anything out there? What would be part of your estate if you passed away? Property, house, money, stocks, land, cars. Yes. All of the above. Yes. So real estate, um, bank accounts, retirement accounts, investment accounts, life insurance, personal property, cash, checking and savings accounts, all of that makes up your estate. There are different ways to transfer your property upon your death. So the easiest way to transfer property is by we call it a direct transfer, and basically this can be accomplished in two different manners. One is by owning property as a joint owner with another person. So often spouses will have real estate titled in both of their names, or they'll have bank accounts titled in both of their names. So that joint ownership functions to get that piece of property or that account to the surviving joint owner upon the first spouse's death. That direct transfer happens basically automatically. Um, if you're married and your husband passed away, basically all you'd have to do is go to the bank, bring a death certificate, and they would remove his name from that account, so it becomes your sole account. And we would do something similar with real estate to get a deceased joint owner's name off of the real estate upon that individual's death. Direct transfers can also be accomplished via beneficiary designations. So you might have heard of a payable on death, transfer on death, POD, TOD, beneficiary designation on bank accounts, retirement accounts, and investment accounts. With those beneficiary designations, whoever you have listed as a beneficiary would get that asset again directly upon your death. Um, People often name children as beneficiaries. And essentially, what happens then is those children would go to the financial institution with a death certificate upon your death, and those assets would be transferred directly to them after you've passed away. The nice thing with these direct transfers is that none of those assets have to go through a probate process. So, has anyone here had to go through a probate process for a family member or loved one? Yeah, we've got a number of people here who have done that. Was it a lot of fun? No, no. It was expensive. Yeah, it oftentimes takes a lot of time, a lot of effort on behalf of the personal representative or executor, and like Pat said, it can add up to a lot of money. So we often like to avoid probate where we can by using those direct transfers or possibly a trust, and I'll talk about that in a minute. But Probate, essentially, for those who don't know, is a court overseen process that transfers assets from the decedent, so the person who passed away, to their heirs or beneficiaries. Um, Anything that passes according to the terms of your will requires a probate process. So it's a misconception that people think, oh, I have a will in place, so I won't have to go through probate. It's quite the opposite. Everything that goes according to the terms of your will requires a probate process to transfer to those named beneficiaries. In Wisconsin, probate takes between 6 months to a year to complete. There are fees paid to the state of Wisconsin. There are fees often paid to attorneys to help you through that process. Um, your personal representative or executor receives a 2% fee for the services that they're providing to your estate. Um, and it's a public process. It's a court process. So your will technically becomes a public document. So does an inventory of your assets and a final accounting showing any debts and expenses that were paid on behalf of your estate. So if you wanted to avoid that process, you can save time and money for your beneficiaries, and ensure your privacy, then I would recommend that we make sure you have beneficiary designations on your accounts, or by setting up a trust. So, does anyone here have a trust or have a family member who has a trust? Yeah, yeah, we've got a good number of trusts. Um, so a trust is a tool to get assets out of your estate, that would be subject to probate and into your trust estate. And basically, how a trust works is, if you have a revocable living trust, in that document, you name a trustee, you also name beneficiaries, and you put provisions in that trust stating how your assets should pass upon your death. So let me start with trustee. Trustee is the person who will have management and control of the assets in the trust. During your lifetimes, typically we're setting up what's called a revocable living trust, which means that you are the trustees while you're living. Um, Oftentimes we've got like spouses who set up a trust, and so the two of them are the trustees, which basically just means that they retain full management and control over those assets during their lifetime. They then name a successor trustee to take over upon their death. And that successor trustee then is in charge of paying final expenses, um, making sure any final taxes are filed, and then distributing the assets to the beneficiaries. And so beneficiaries are the people, the individuals, or the entities, who will receive assets upon your death. During your lifetime with a revocable living trust, the creators of that trust are also the beneficiaries. So they still get the full benefit of the assets in that trust. But then we name beneficiaries to get those assets upon death. And that is, that can be anybody. It can be your children, it can be friends, siblings, charities, whoever you would like to receive those assets, would then be named in your trust document. Um, I really like trusts for any individuals who are, looking to put restrictions or, protections in place for their named beneficiaries. So if anybody here had any minor beneficiaries, whether that's grandchildren or nieces and nephews, or any beneficiaries who are disabled, so anybody who might be receiving SSI, or Medicaid, and who can't receive those assets outright, should consider looking into getting a trust put into place. Um, because we can restrict how those funds are used so that it doesn't disqualify your beneficiaries from receiving, that SSI or Medicaid. As far as minor beneficiaries, We can name different ages at which they can get assets outright. And we can also put in place provisions stating how the funds can be used for that minor beneficiary's lifetime. Does anyone have like a grandchild? Okay, we've got a couple grandkids in here. Um, so if you passed away and wanted to give them money, you might not be comfortable with them getting that money right now. Who has like a minor beneficiary? How old is your grandchild? Two. Okay. Yeah. So your 2-year-old grandchild can't get money outright, right? Yeah. So what we would do if you wanted to leave money to them is we'd put into place a provision stating that your 2-year-old grandchild would get a certain amount of money, but that they couldn't get it outright until they reach a certain age, or maybe until they completed a certain task, like graduated from college or something like that. And then we could say during the term of the trust, they could ask for money for certain purposes, maybe for education, or for buying a car, those types of things. So with trust, we can be really flexible and creative with the provisions that we put in place there. It's also a great tool for anybody with like any business assets or any real estate, especially if you're wanting that real estate to stay in your family, but also wanting to maybe give like common provisions. We include our giving kids or grandkids like a first option to purchase real estate, um, especially beneficial for people with farmland or land that's been in the family for a long time and you're wanting to keep it in the family. Um, any questions about trusts? No. Or okay, yeah. For setting up a trust? It really depends. Locally, I'd say anywhere from between 1,500 to $10,000. It really runs the gamut. It kind of depends on the complexity of the document, and who you're going to for those services. Okay, yeah. So the question is, if you set up a trust and then a spouse becomes ill and needs to like go into a nursing home and qualify for Medicaid, that's a good question. So a revocable living trust doesn't remove any assets from your estate. So it doesn't provide any protections for Medicaid and nursing home planning. That would be a separate discussion that you would need to have with an attorney. Heather, I don't know if you want me to get into Medicaid and nursing home planning now, or um, I can, yeah. Maybe when I'm done talking about estate planning, I'll talk more about that. And if you have more questions, you let me know. And then you had a question? Yeah. Yeah. Okay. So what's the difference between an irrevocable trust and a revocable trust? A revocable trust can be amended, changed, terminated at any time during the creator's lifetime. It does become irrevocable upon the creator's death. So nobody can change it after that person has passed away. An irrevocable trust cannot be changed or amended without a court order or without some very specific steps being taken while that individual is alive. So, the creator of an irrevocable trust is putting assets into a trust to remove it from their estate and essentially remove it from their management and control. The reason you might do this is for Medicaid and nursing home planning, and possibly for tax planning. If you had a large taxable estate, that would be one way to reduce your estate tax consequences. Um, it's a huge step. So once you put assets into that irrevocable trust, you can't get them back out. Again, without a court order. You can't change the terms of that trust. Um, And like, let's say you put a house into that trust. You're also, so you're naming a trustee other than yourself. So that's the person who has control over those assets. If, for example, the house was sold, those sale proceeds would stay in the irrevocable trust. So you couldn't get them back out except according to the terms of the document. So oftentimes those irrevocable trusts allow for distributions of income to the creator during their lifetime, but it preserves the principle of those assets for the beneficiaries upon the creator's death. Does that answer your question? Possibly. Here, I will just dive into nursing home and Medicaid planning right now. So, um, basically, if anybody here were to go into a nursing home tomorrow, what would happen is you would have to pay for your nursing home care out of pocket until you could no longer afford to pay for that care. So locally, nursing home expenses are around $9,000 to $10,000 per month, so it's quite expensive. But you would have to, it's called spend down your assets on your nursing home care until you qualified for Medicaid. Or maybe some of you have some long-term care insurance that'll go towards your nursing home care as well. Um, in order to qualify for Medicaid, you have to have less than $2,000 in your bank account and less than a certain amount of income as well. So, if you've got some retirement and Social Security income, that would go towards your nursing home care. And then you'd have to kind of spend money from other assets that you might have until you get down to that $2,000 asset limit. Um, Medicaid then would kick in to cover whatever your, Social Security income doesn't cover. So, if you have income of $4,000 per month, then Medicaid would cover the additional $6,000 to pay for your full $10,000 of nursing home care per month. Is essentially how that works. Um, if you're an individual, either a widow or a single individual, all of your assets would be what's considered an available asset that would count towards that $2,000 asset limit. If you are married and only one spouse goes into the nursing home, then I'll just say the husband goes into the nursing home and the wife is still at home. So if the husband is in the nursing home, all of his assets are considered available assets that count towards that $2,000. The wife, however, has some spousal impoverishment protections. And so essentially, that just means that if she's still living in the house is not counted as an available asset. She continues to live in the house and it is protected for as long as she's living in that home. Um, she also would her qualified retirement accounts would also be protected. So things like IRAs, 401ks, and pensions for the wife in this situation would not be counted as an available asset. And then one vehicle would be protected, and then so would an additional, it's approximately $150,000 in additional assets would all be protected for the wife if she was still living at home and the husband went into the nursing home. So basically, Medicaid would just kick in. I think for either whenever you can no longer afford to pay out of pocket. Different nursing homes locally have different rules on like when they'll accept someone who's receiving Medicaid. Like oftentimes they'll require you to pay out of pocket for a certain number of years before they would even allow you to move in. So if you're already at the $2,000, they might say no. Yeah. Sure. Yeah. Yeah. So yeah, space available in the nursing home would also depend on whether or not you'd be able to get into the place that you want to be. Yes. Yeah. So the question is, can the state or the nursing home take your house after the wife dies? If she's the one who was living at home and the husband was in the nursing home, what happens to the house when the wife dies? So that's a very good question. The state of Wisconsin, via the Medicaid program, will put a lien against the home while the wife is living there. And so, yes, if she dies, then they would be able to require the personal representative or trustee or whomever is administering the estate to sell the house. And then a certain amount of those sale proceeds would be paid back to the state of Wisconsin to basically reimburse the state for as much money as they have paid out on behalf of the individual in the nursing home. That is part of what's called the estate recovery program, where essentially the state is looking to be reimbursed for any expenses that they've paid out while the individual was living. Yes. Yeah, I'm not sure if most in-home care is covered by Medicaid. I might be. I'm not sure. Any other? Yes. Yep. Yeah, yeah. Okay. So, when is it too late to put your assets into an irrevocable trust? So, when you qualify for Medicaid, so on the date that you have $2,000 in countable assets, Medicaid will look back for the last 5 years to see whether you have made any divestments. A divestment is the transfer of property for less than fair market value. And so that can be putting a house into or any asset into an irrevocable trust. And also just outright gifts to kids or other beneficiaries. And so basically, any nursing home planning that you might do would constitute a divestment. Uh, so, um, so if you've made any divestments within 5 years of qualifying for Medicaid, then the state will put in place a penalty period where they will not cover your nursing home care. And that period is based on the value of the divestment that you made. So they take, the value of the divestment, divide it by the daily nursing home rate, and then that's the period of time that you have to come up with money to pay for your care, which puts you in a sticky spot because you only have $2,000 in countable assets. So, um, if you put your house into an irrevocable trust, you need to make sure that you have at least 5 years worth of assets to cover you for nursing home care after putting it into the irrevocable trust. Um, so if you're already in a nursing home, we're going to have to go through your other bank accounts and everything to make sure there's enough liquid assets to cover your nursing home care before we even talk about putting it into an irrevocable trust. Mhm. Um, Same thing. Outright gifts of cash to kids are divestments as well. So if you give $10,000 to your kids to get it out of your estate to protect it for nursing home purposes, we're going to want to make sure you have uh, enough money to make it through the next 5 years, or else make sure your kids are willing to give that money back to you if necessary. um, I touched on estate recovery. So the state of Wisconsin can recover from any of your assets, including non-probate assets. So that would include like life insurance proceeds, retirement accounts, those types of things. So they are looking to get back money that they have paid to you essentially, and they're pretty good at that. Okay, so this question is if two siblings are living together and one sibling goes into the nursing home, can the state of Wisconsin recover from the other sibling? Um, so that depends. If the house is in the name of the sibling who does not go to the nursing home, then no. If the house was in the name of the sibling who did go into the nursing home, then yes. But otherwise, it's just the ability to recover from spouses. Mhm. There are other exceptions too, like if you have a disabled child living in your house, then they wouldn't recover um, from the home in that instance. Or if you had a child living with you, a child caretaker living with you for a number of years before you went into the nursing home, you could give the house to that child caretaker, and the state of Wisconsin would not recover. That it's a very strict requirement that that child caretaker essentially provide the um, the amount of care that is essentially keeping you out of the nursing home. And so that often requires a doctor's note saying that this child was providing such a level of care that the individual would otherwise have been in a nursing home. All right. Any other nursing home questions? Yes, correct. Oh, absolutely. Yes. Yep. Yep. So, yeah, Social Security is kind of an automatic payment that you get because you paid in during your lifetime. Medicaid is separate. Medicaid is a needs based program that you must apply for and qualify for before you start receiving those funds. So, yes, you will absolutely know whether or not you're receiving Medicaid. All right. Okay, so I talked a little bit about trusts and beneficiary designations. I haven't talked about wills yet. So a will essentially is a document that we would use if you don't have a trust. And it's a great way to name a personal representative or executor. That's the individual who will be in charge of making sure your final debts and expenses are paid after your death, and then also naming beneficiaries. I like to use wills in conjunction with beneficiary designations on accounts and policies, because then ideally we're hopefully still avoiding probate, but also making sure that an individual was named as your personal representative. If you don't mind your assets going through a probate process, then a will also is a good tool. Probate can sometimes be good. Like if you know that you have beneficiaries who are going to fight with each other, and you want that court or oversight, then maybe you want your assets to pass through a probate process. I've had situations where it's gonna end up in court anyway, so we just go straight there and set up that forum uh for the disagreements, and then you have a judge who's there to kind of help you through that process. um you would also wills are required to name guardians for minor children. So if you had children under the age of 18, you would need to name that guardian in the will. And that guardian would be nominated in your will, but they would be approved by the court in a short guardianship process after you passed away. Any questions about wills? Yes. Mhm. Yeah, so if you have a POD on a bank account, does it have to go through probate? No, that is a direct transfer to the named POD beneficiary. So, for example, if I have a bank account listing my husband as my POD, as my beneficiary, but then my will says everything goes to my sister, that bank account is going to go to my husband, because those beneficiary designations work outside the terms of your will and supersede the terms of the will. Um, yes. Yep. So if you have a bank account with your name and the name of a child, then that would go to that named child. So that is if they're a joint owner, is that, or are they a POD beneficiary? Oh, okay. Okay, so it kind of depends on what it means by putting their name on the account. If they are named as a joint owner, then that automatically gets the account to the child upon your death because of that joint ownership. That is something I like to caution clients about. Is let's say you have three kids and you name one of them as a joint owner so that they can help you pay your bills and those types of things. Technically, that one child becomes the sole beneficiary of that account upon your death, and they would not be required to share those assets with their siblings upon your death. If instead they're named as a payable on death beneficiary, then they would get that upon your death without probate. Um, and if you wanted them to assist you with paying bills during your lifetime, then I'd recommend getting a power of attorney document in place. Any questions? Otherwise, I'll talk about power of attorney documents. Okay. Okay, so power of attorney documents are super important for planning for your incapacitation during your lifetime. We have two different documents. One is the power of attorney for finances, and the other is the power of attorney for healthcare or advance directive. Um, a power of attorney for finances. In this document, you name an agent to make financial decisions for you during your lifetime if you're not able to make those decisions for yourself. Typically, your agent can do things like pay bills for you, manage investment accounts and retirement accounts. They can get you insurance, like Medicaid. They could help you with that Medicaid application. Um, they can file your taxes for you, those types of things. There are certain things that your agent cannot do for you, which includes changing like your will or your trust or your beneficiary designations, unless you explicitly allow for that in the document. Um, I think it's great to have these in place in case something were to happen to you and you are no longer able to make those types of financial decisions. I recommend having at least two people named, like a primary and then a backup agent, in case something happened to your first choice before you were able to update the document. Um, you can draft, oh, sorry, yep. Mhm. So are there tax consequences for naming your children as joint owners on your account? Um, n- uh, Probably not. So right now, the state of Wisconsin does not have any estate tax um, at all, estate or inheritance taxes. So nobody has to pay estate taxes at the state level. At the federal level, nobody's paying estate taxes unless they have over about $13 million per person. So spouses can pass up to $26 million without paying any estate taxes. So very few people have to worry about that right now. Um, as far as the asset having your children's name on it, um, if it's an appreciating account, um, then I would recommend that your children be named as payable on death beneficiaries. Like, let's say you have some stocks that you bought in the 90s and they've grown exponentially in value. Then instead of gifting it to your children during your lifetime, we would want them to inherit it so that they don't have to worry about capital gains taxes. So capital gains taxes are taxes that are paid on the increase in value of an asset from the date that you got it to the date that you sold it. So if you bought some Apple stock in the 90s for, I don't know, $100 and now it's worth $100,000, then that would be, uh, 99 $90,000 worth of capital gains taxes that you would have to pay. And so when a child inherits property from you, and this is important for like real estate as well as stocks, they get what's called a step up in basis for tax purposes, so that they inherit that property with a value equal to the value of the asset on your date of death. So that then, if they sold it shortly after your death, they don't have to worry about capital gains taxes. Sure. Yeah, that's a good question. Yeah. Yeah, possibly. Yeah, so she made a good point, that these laws were put into place under the Tax Cut and Jobs Act, and that those rules sunset in 2025. So the question is, how does that affect your estate planning? Yes, I would probably get it done before those rules change. All of these laws, especially the tax laws, are subject to change based off of the current administration that's making these laws. Like the estate tax exemption also is going to go down to around $6 million unless Congress acts in the meantime. Which it's really hard to predict whether or not they'll make changes, and if they do, what those changes will be. The step up in basis, I don't really know how we plan around that, because that is a law that affects your date of death. So, if you make a gift to your child, though, during your lifetime, you are ensuring that they have your initial basis in that property. So I don't know if it's worth it to make the gift now, um, uh, because if the laws do change, or I mean, it doesn't matter whether or not the laws change. You're establishing what their initial basis is on the date of that gift, um, which is typically not beneficial for the child if it's a highly appreciating asset. Typically, yeah. So the question is, if you have like an interest bearing stock account and you put that account into an irrevocable trust, can you still use the income or the interest from that trust? Typically, yes. The trust document will be drafted so that you can use the income from that asset, but the principal of the asset would be protected against your use, essentially. All right. Any other questions? Yes. Mail order wills. Maybe. I don't recommend them. Not to say that you can't do it. Basically, the state of Wisconsin does require that you sign a will in the presence of two disinterested witnesses, for it to be a valid will in the state of Wisconsin. So, like, sometimes it's called a holographic will, a handwritten will with no witnesses. That would not be valid in the state of Wisconsin. Um, Another thing that's not valid is, let's say you do execute a will properly, handwritten notes on it, those are not valid. Uh, Everything in that will, for it to be valid, would require the two witnesses to verify that you were the individual who signed it or who made the change, and that you were of sound mind when you made that change, or when you initially signed the document. So those are the requirements for signing a legally binding will in the state of Wisconsin. Yes. Yes. You can gift up to $18,000 per person per year without having to pay gift taxes. Um, Uh, However, you can gift more than that, and that would currently be deducted from your lifetime exemption amount of $13 million. So if you gifted more than $18,000, to one of your children, that would just reduce your $13 million that you can pass upon your death. You'd want to make sure you talk to your accountant about that, though, because they will want to make sure that a gift tax return is filed with your taxes that year, just so that the IRS knows that you're making these gifts. Yeah. So how often do you need to update your will? If everything in it is still valid, I would say you don't need to update it. If any of your wishes have changed or any of your beneficiaries have died or become disabled or are in a nursing home, then we'd want to update it. So my recommendation is that you look at your estate plan documents upon any major events in your life. So whether that's a death in the family, a disability in the family, a new birth in the family, those should all trigger you at least taking a look at those documents. If they don't need to be updated, great. Leave them as is. Otherwise, if none of those things happen, I'd say at least look at it every 5 years or so. I know it's asking a lot. I have clients who haven't updated in 40 years, but I recommend at least looking at it regularly, if not actually making the updates. Oh, yes. Yeah. Sure, yeah. The question is, does the law firm hold on to a will, and what happens if the law firm goes out of business? Law firms no longer hold on to original estate planning documents. It's now considered kind of a conflict of interest because those original documents are required for a probate process, and so we don't want family members to be required to come to our office to open a probate matter. So we send original documents with the client and recommend that you keep them somewhere safe and let your survivors or your loved ones know where to find those documents. We keep copies of everything. And so if the law firm went out of business, technically, attorneys are required to have a succession plan in place, especially like solo practice attorneys. They should have another attorney or another firm named to take over their files in the event of their death or retirement or whatever. So wills actually are not recorded or put on file anywhere until after you pass away, and that is done during a probate process. So once you get your estate plan documents done, put them somewhere safe, and let your loved ones know where to find them and how to find them and access them. All right. So then I think the last document I haven't talked about yet is a healthcare power of attorney or advance directive. So if you haven't already done one, and if you go to Gunderson or Mayo, they probably ask you every time you go in for an appointment whether you have your advance directive done. um, an advance directive is a document where you name an agent to make healthcare decisions for you if you were unable to do so. And then you also write in what types of decisions your agent can or cannot make for you, and what your wishes are regarding any like life prolonging treatment and medical care that you might be receiving at the hospital. Um, Wisconsin is not a next of kin state, which means that if you became incapacitated, your direct family members do not automatically have the right to make your healthcare decisions. So you absolutely have to have somebody named in the document if you want someone to be able to make those decisions for you if you became incapacitated. Without this, we'd have to go through a guardianship proceeding. And that's another court proceeding where we would name a guardian for you to make those healthcare decisions. And that requires um, medical providers report. It requires sending notice to all of your immediate family members. It usually takes about a month to get a guardian named. It costs a lot of money um, and a lot of stress to your family members. So get your advance directives done. whether it's with an attorney or directly with your medical provider. Both Gunderson and Mayo have wonderful programs, free programs where they will have a social worker who will fill out that advance directive with you. They'll make sure it's properly executed by two witnesses, and they will make sure it's put on file with your medical provider. So if you do one thing today, or after you leave here, go get your advance directive done. Um, the advance directive does not come into effect until two physicians should make a determination that you are unable to make your own healthcare decisions. So, just something to keep in mind. Yep. That's a very good question. I do recommend naming your personal representative or trustee or, child as as someone who can access the safe deposit box so that they would be able to get those important documents out of the safe deposit box after you pass away, because like you said, otherwise they don't immediately have access. If they're not named, it's not the end of the world. Basically, what would happen is, if you pass away, they would go to the bank, and the bank would allow them to do an inventory of those assets, so they could write down that, there's a will in here, and there's a the title to the property and whatever. But then it would require, probably a court order to be able to withdraw those assets in the safe deposit box. So it is beneficial to have somebody named to be able to get them out, without requiring any court intervention. Mhm. Correct. Yes. My understanding is that the hospitals don't allow you to make amendments to advance directives. They do require you to do an entirely new document. Um, it's about a 10-page document. A lot of it is just kind of explaining what your rights are. So it's not an overly complicated document, although it is one that you should take very seriously, and put a lot of thought into. Correct. Yes, you absolutely do not need an attorney to do an advance directive. The hospitals offer them for free, and have their social workers go through it with you for free as well. You can also just find the documents online if you search Wisconsin Advance Directive. Do make sure it's Wisconsin specific, though, because Wisconsin does have some specific requirements for the advance directives. Yeah. Yes. Mhm. Yes. So a post order or a physician's order for, what is it? Life-saving treatment is a document that, it's basic, it's yellow, correct? It's a yellow document that you would get from your physician, and you'd put it on your refrigerator or somewhere easily viewable in your home, um, and in your medical record. And it's basically, in that document you indicate what your life, that you don't want to be resuscitated, essentially, is what those, what they're immediately used for. Okay. Okay. Yes. Right, right. Yes. Okay. So, yeah, she was just explaining that the post order has, some more specific requirements or, uh, wishes specified in that document, um, beyond what is included in the healthcare, advance directive. Um, I most often see them used by clients who, don't want to be resuscitated. They'll have that post order, on like their refrigerator so that emergency, um, responders know that they should not provide that CPR upon arrival at that individual's home. Yes. Um, so hospital documents are not included in the will. They are separate documents. But if you went to an attorney for an estate plan, they would include the will, um, and or trust and the advance directive and the power of attorney for finances. So it would be part of your estate plan. But a will only governs the distribution of property. So it doesn't have anything to do with, yourself as an individual person. So it is kept separate. I should also point out there's another document your attorney might provide to you, and that's called an authorization for final disposition. Again, that's separate from your will, but would be included in a plan. And that's a document where you set forth your wishes as far as um, like whether you want a funeral or a celebration of life and what type of celebration you'd want and whether you want to be cremated or buried and those types of things. Correct, correct. Yes. So the advance directive is a comprehensive document that sets forth those wishes as far as life prolonging treatments go. So like you were saying, if you are nearing death, your physician is required to provide treatment for you because of their Hippocratic oath. But if you've said in your document that you don't want to receive treatment, then they would be able to go to your agent who would say, no, don't put her on a ventilator or a respirator because this is what her document says. So your agent interprets your wishes set forth in that advance directive in conjunction with your physician. But ultimately, your agent has the final say on whether or not to provide that life prolonging treatment, which they must do in conjunction with the wishes set forth in your document. So if you don't have those wishes set forth somewhere, how do they make that decision? They can't. That's a great idea. So she pointed out that she travels often and carries a copy of her advance directive in the glove compartment of their vehicle. I think that's a great idea. I recommend you take a copy of it whenever you're traveling. If you don't want to take the whole document, the you can have like a little card that says, "I have an advance directive. It's on file with whatever hospital. Here's my agent. Here's my agent's phone number. So if something happened to me, call my agent, and they'll be able to contact my physician." Medical records are easily transferable these days between hospitals. Yes. Yeah. Oh, yeah. So a quick claim deed actually is a document that transfers your property during your lifetime. So we use quick claim deeds for like if you're gifting a house to an individual or um, it works in the same way as a warranty deed. Like when you buy your house, you probably got it on a warranty deed, except that a quitclaim deed does not make any representations or warranties as to the title of the property. So it is not the same as a TOD. And I actually don't think I talked about transfer on death deeds. But a TOD or transfer on death deed for your house is a way to transfer your real estate directly to beneficiaries upon your death. So it's different from a quit claim deed in that it's not a completed transfer until after you pass away. So if you did decide to sell the house or something like that, it doesn't have any effect on that. It just becomes a void document. But it does ensure that your real estate does not have to pass through probate after you pass away. Very good question. Yes. The transfer on death deed is recorded with the Register of Deeds, not the courthouse. You could record it on your own. There are some very specific requirements, so I would maybe recommend at least consulting with an attorney. You need to have like your correct legal description and parcel identification number on there. The legal description on your tax bill is not the full legal description. So we just want to make sure that it's done properly. Yes. Yes. Yep. The transfer on death deed needs to be done and filed before you die. And yep, correct, correct. Yep. Yes, because it's a deed. So anything with real estate does have to be recorded with the Register of Deeds for it to be legally binding. From where I'm standing, it looks like the correct form. Does it say non-probate transfer on death deed at the top? Yes, it has to be notarized. And yep, so it needs to be signed by the current owners. You need to have the current owners' names on there exactly as they were written on the original deed when you acquired it. You need your beneficiaries' names, and then you need the legal description of the property and the parcel identification number. And then your signatures need to be notarized, and you need to record it with a $30 recording fee at the Register of Deeds. Because the non-probate transfer on death deed is not a transfer right now, it does not require that electronic real estate transfer return. Sure, yeah. So she asked what my fees specifically are for estate planning packages. So for a single individual, for like a will, power of attorney documents, and we include like the transfer on death deeds if that's something that you should need. We do a flat fee of $300, so 600 for spouses. For trusts, it's a little bit more expensive. It is a higher upfront cost, and that is usually between $1,200 to $2,500 for the trust documents because it's a little more complicated. Yes. Yeah. So her question is, with a deed and title, are you supposed to have like a deed or a title to your house somewhere? Yes, at some point you had one. If you lost it, do not fret because the Register of Deeds has copies of everything that has been recorded. I don't even know when it first started, but if you bought it anytime within the last 100 years, I think, then they would have a copy of your deed. So we would be able to get a copy of it. If it's in La Crosse County, it costs $3 to get a copy of that deed from the Register of Deeds. Right, right. Yeah. So she was asking if you have a mortgage, can someone come in and take over those payments? So, like, even if you passed away, no, they're probably going to require like, if you give it to your kids, they're going to require them to refinance it. Some banks don't, but typically what happens is if the real estate is sold upon your death, then that mortgage would be paid off, and then your survivors would get the remainder. Or if somebody wanted to continue living in your house, then they would probably have to refinance with the bank, probably at a higher rate, depending on where we are on that date. And yeah, so yeah, you can't just give it to somebody and allow them to assume your mortgage without the bank's approval. Oh, sure. Yeah. Can someone scam you out of your house? They can try, but yeah, probably not. If you are concerned about that, you can go to the La Crosse County Register of Deeds website and you can get like a notification where you would then be notified if somebody tried to file something that would affect the title of your real estate. I believe you could go to like title companies' websites as well, but I would say go to La Crosse County Register of Deeds website, um, and they'll have a, a section where you can put that notification into place. You could go directly to the Register of Deeds as well as just right down the block. Okay, so she asked, how can you prepare for possibly needing to pay capital gains taxes on unrealized increases in value, right? Uh, yeah, I would say that is a good question to ask your financial advisor and your accountant. So, I work very closely with clients, financial advisors, and accountants. They kind of give recommendations for financial investments, tax planning, and then I create whatever legal document is needed to carry out those recommendations. So I don't have an answer for you on that one. Yeah. What is the downside of putting your house into an irrevocable trust? So a couple downsides. One, like I said, once you put an asset into an irrevocable trust, you can't get it back out without a court order. And you're naming a trustee to manage that asset. So you're relinquishing control of that asset to the trustee. The other downside is that irrevocable trusts, you're removing that asset from your estate. So you have similar problems with capital gains taxes as you do with gifting an asset to a child directly. So you would also have capital gains tax consequences if you put a house into an irrevocable trust. All right. Well, I think we're past our time. So thank you so much for having me. If you do have any questions, I've got some cards up here. I'm happy to give those out. Otherwise, thank you again for having me today.